Hi, my name is Pradeep Sivanathan, otherwise known as Seva, and I am the founder of the Seva Law Firm. I wanted to take some time to introduce myself and the firm and welcome you to the Seva Law Firm. I also wanted to thank you for choosing us to represent you for your car accident case. First, I understand that this is a difficult time in your life. Car accidents are stressful on many levels. You're in pain, you have anxiety, you can't sleep well, you need help with simple tasks that you used to be able to do on your own. You can't enjoy your hobbies anymore. You're starting to get out of shape because you can't exercise anymore. And for many of you, your bills are piling up because you can't work and you have no income. It is an incredibly stressful time for you. I understand that. I sympathize with you. But we at the Seva Law Firm are here for you. And we want to help you de-stress and provide you with some comfort. And so I wanted to start out first by saying that, and don't forget this, everything is going to be okay. You're going to get through this, you're going to get better, you're going to get back on your feet, and we're going to be there for you every step of the way. Now, since we're in the age of remote meetings and Zoom, I don't get the opportunity to interact much with clients as regularly as I used to. And so I felt that it was important to send you this video message so that you could put a face with the names that you would be dealing with. I believe it's important for you to be comfortable with who you are entrusting your legal case to. These days, there is typically little to no interaction between attorneys and their clients. And while this video isn't a substitute for that interaction, I'm hoping that it will provide you with a little bit of that comfort. I also, very importantly, want to use this video to educate you on your rights and limitations after a car accident, and also how the legal process works. I want to teach the law that applies and dispel all of the misconceptions and false narratives that are pushed by TV commercials. By the end of this video, I'm hoping that you thoroughly understand how the process works and what you can expect. But before we get into the educational portion, let me first tell you a little bit about the Seva Law Firm so you know who we are. The Seva Law Firm is a plaintiff side litigation firm that has specialized in car accident cases for over a decade. We have a staff of nearly 30 employees, including 7 veteran attorneys who are highly experienced and knowledgeable on everything related to car accidents. Our firm has won numerous awards for our work including Super Lawyers, B-Business, Top Lawyers, Michigan Top Lawyers, Elite Lawyers, Avos Client Choice Awards, and many more. All of this you can find on our website. You can check us out. We have an A+ rating from Better Business Bureau as well, and also a near perfect Google rating. I urge you to check us out, see for yourself. We've also won many trials and appellate decisions. Several of our lawyers have been selected to the Michigan Association of Justice Executive Board, and several of our lawyers regularly lecture on car accident litigation at seminars. Personally, I've been a car accident litigator for nearly 2 decades. I spent 4 years on the defense side representing insurance companies before I was enlightened and switched over to the plaintiff side, to the good side, I call it. But during my 4 years of representing insurance companies, I learned all of their practices, their methods, their dirty tricks. I learned how they employ the 3 Ds: delay, deny, and defend, to try to avoid paying anyone. It was invaluable experience that I have brought with me to the plaintiff side and to the Seva Law Firm. And I ensure that all of our attorneys and staff know not just the law, but the best tactics that I learned along the way as a defense attorney to beat the insurance companies. Now, speaking of my staff, let me introduce you to the ones that you will be dealing with the most on a regular basis. First, while your case is in its early stages and the insurance company has not yet denied your claims, your case will be with our pre-litigation department, which is comprised of Nick Doherty, our intake and pre-litigation attorney. He's the attorney you'll be dealing with until your case is ready for litigation. Kim Sullivan, she is our pre-litigation manager and medical provider liaison, She will help coordinate your treatment and ensure that your claims are being processed with the insurance company. Kevin Michael Cabbage is our lead intake specialist. He is the one that gets all the necessary information to ensure that your claim gets filed and processed expeditiously. If your claim does get denied by the insurance company at some point, and nearly every claim does, your case will then move to our litigation department. There you will be assigned one of our litigation attorneys, Manpreet Gill, Omar Sharif, Ashley Burkhart, or Ibrahim Hamoud. You'll also be contacted by our litigation manager from time to time, Janelle Savaya. She deals with a lot of the questions. She will be able to answer a lot of the questions that you have while the case is in litigation. Also, Elvira Overshevsky, who's our other litigation paralegal. Obviously, there may be others from our firm that contact you from time to time, but these are the main individuals from our staff that you will be dealing with. So, by the end of this video, I'm going to cover the topic that you're probably most interested in, which is how much am I going to get out of this case? But before I get into that, I want to educate you on what you're entitled to after getting into a car accident. This way, you will know what your case is about, and you can get a better sense as to what you can recover from your lawsuit, what determines the value of your case, how the claims and litigation processes work, what are some of the potential pitfalls for your case, and how do you put yourself in the best position to get money out of your lawsuit. So let's start first with what are you entitled to claim when you get in a car accident. There are typically two types of claims that you can pursue when in a car accident in Michigan. The first claim you're likely entitled to is a claim for no-fault benefits. This is sometimes called PIP. It's also called first-party benefits. So no-fault, PIP, first-party, it's all kind of interchangeable, and I'm going to use all of that throughout this video, and throughout your case you're going to hear those terms used interchangeably. No fault, PIP, and first party benefits are all the same, and they essentially mean your economic claims from your car accident. So in short, your no fault claims are essentially economic damages with your own insurance company. The economic damages you're entitled to include payment of medical bills, payment of attendant care, payment of replacement services, and payment of lost wages. And I'm going to go through each of these quickly in a second. Before we can start figuring out what we can claim, we need to understand the first step to starting the process, which is we need to figure out and determine what is the correct insurance company. What is the correct PIP insurance company? If you do not file a claim with the correct insurance company within a year of the accident, you will be forever barred from making a claim for no-fault benefits. Also, if you try filing a claim with the wrong insurer, they will not pay and they will win any lawsuits you file. So it is very important to identify the proper insurer as soon as possible. Now, before the changes to the No Fault Act in 2019, the major changes that I'm sure you all heard of on the news, it was very confusing to identify the proper insurer. But as the law currently stands, it's much easier. For most of you, if you or your spouse have purchased car insurance, that insurer is going to be responsible for PIP benefits. So if you bought insurance and you have an insurance policy, that is going to be your PIP insurer, and it's a very straightforward process. If you or your spouse do not have your own insurance, then you must claim through a family member who you live with that has car insurance. So if you're living with a parent who has insurance, or an aunt or a grandmother, uncle, whatever it is if they're related to you and they have insurance, you must file a claim through their insurance. If you don't, and the insurance and you try to process a first party claim, it's going to get denied. And we've had situations where people did not want, where our clients did not want their cousin's insurance to go up, their premiums to go up, so they did not mention that their cousin had insurance. And we went through a case, and the insurance company conducted discovery and found out that the cousin had insurance, and then the case ended up being dismissed because our client was not forthright and did not tell us that their cousin had insurance. So it's very important that you identify if there is a family member in the household that has insurance. So again, the order of priority is that first you must go to your own insurance company, and then if you do not have your own insurance, then to the insurer of a resident relative. If none of that applies, then you must seek insurance from the Michigan Assigned Claims Plan. The Michigan Assigned Claims Plan, which we call MACP for short, is a state-run program that will assign you an insurance company for your claim if you don't have any coverage that applies. And it can be any participating insurance company that is assigned to you. AAA, Nationwide, Citizens, Farmers. It's a completely random draw that the MACP selects. One caveat is that if you were driving your own car in the accident and you do not have insurance, you cannot apply to the MACP. You're essentially barred from benefits if you're driving your own uninsured car. And there's a few other more complicated scenarios which I will not get into right now. If you have this scenario, then contact us and we'll tell you what the plan is. But if you were in a Lyft, an Uber, you were in a bus, you're from out of state, or you were traveling out of state when the accident happened, there's a different analysis. But just in general, you should know your own insurer first, then resident relatives, and then MACP. And the last thing on this topic is, just to be clear, you cannot claim PIP benefits from the at-fault driver's insurance company. So the person who hit you has nothing to do with no-fault benefits. With your first-party case, the person who hit you has nothing to do with that. That is a separate claim. It's called a bodily injury claim, which we'll discuss later, but it has nothing to do with your no-fault benefits. In Michigan, we have a system where your own insurance, the no-fault carrier, will pay for all of your economic damages. Now, let's get back to the various benefits that you're allowed to claim in a PIP case. So the first thing I mentioned is that your no-fault insurer is required to pay for all accident-related medical bills. Now, in theory, that sounds simple, but in actuality, it's not that simple. First off, the car insurance will not pay for medical bills if you have a coordinated policy or you opted out of medical coverage when buying your no-fault policy. And this is something that is very common after the amendments to the No Fault Act in 2019. A lot of you have opted out of your medical coverage, and some of you may not even have known this, but you chose elected a very a cheaper policy from the auto insurer that requires you to go through your health insurance. If that is the case, then you may not have a PIP case, you may not have a first party case, because a lot of the benefits are covered by that medical clause. Second, the insurance company is not responsible for paying bills that are not related to your accident. So of course, the insurance companies are going to try to say that many of your bills, or all of your bills potentially, are not related to the accident. And they do this because their goal is to not pay. The insurance company only needs to pay for the services that are reasonable and necessary for your accident-related injuries. So just because you've incurred these bills doesn't mean they're going to get paid, and that's part of the reason why you need an attorney to navigate through this. Further, if the PIP insurance company believes that your doctor is charging too much for their services, they may also decline payment or only pay a portion of the bills, like it's a very small amount, because again, ultimately it is the insurance company's goal to pay as little as possible. That's how they make their money, and I'm going to discuss that later. The next benefit you may be entitled to is replacement services. If you need help around the house with cooking, cleaning, laundry, mowing the lawn, etc., you can claim something called replacement services from your PIP insurer. This is a benefit where the insurance company will pay you $20 per day for help around the house. That $20 a day was established in the 1970s and has not changed since. It's a very low amount and quite unfair, but it's something that you should be claiming and you should be keeping track of. Replacement services are a benefit you're entitled to for 3 years, and then it ends. And in order to get replacement services, you do need to get a prescription or a script from a doctor saying that you need these services, and you need to keep track of these on a calendar or a log, and we will provide you with these logs. A family member can provide these replacement services to you. It doesn't need to be someone from the outside. So if you have a parent or a sibling that is going to be providing the care or the services, that's perfectly fine, just as long as they keep track. This is a benefit that you're entitled to, but the insurance company will often not pay, or they'll pay for a certain time and stop and then force us to file suit. The insurance company is going to argue that you don't really need the help around the house, or that the reason you need help is because of an unrelated issue. I should note that replacement services are different from attendant care. Some of you already know about what attendant care is and have heard of replacement services. They're both a benefit where someone is taking care of you essentially, or helping you, but they are two different types of benefits, and I'm going to get into attendant care later. That is more of when someone is taking care of your personal needs, and it's a much more valuable benefit because it's reimbursed at a higher rate. The next benefit that you're entitled to is that you may be entitled to is wage loss. If you were working at the time of the accident and when unable to work after because of injuries related to the accident, you may be eligible for work loss benefits from your PIP insurer. Wage loss benefits are paid at 85% of your income based on your last month of work. In order to claim wage loss, you will need to submit tax returns and pay stubs as proof of income. You also need an order from a physician stating you are disabled from work. Like with replacement services, this is only a 3-year benefit, and there is a statutory cap on how much you can claim. If you are self-employed, the calculation of your wage loss can become very complicated, and it's something that you should discuss with us as soon as possible. And then the final benefit I want to discuss that's part of your first party claim is attendant care, which is technically part of your medical coverage. And if you don't have medical coverage, then you can't claim attendant care. But I like to think of attendant care as a separate benefit because it is an expense that can be paid directly to you and not to the doctors. Is sort of a medical bill that's paid directly to you instead of to a medical provider. So what is attendant care? Attendant care is essentially getting help with your personal care such as putting on your clothes, helping you in and out of the bed, helping you in and out of the couch, helping you walk, doing your hair, giving you meds, feeding you, supervising you so you don't fall, things like that. This is a very valuable benefit in PIP cases, and it is, I would say in fact, that it is the most valuable benefit to injured plaintiffs from a monetary standpoint. And the reason the attendant care is so valuable from a monetary standpoint is that it is reimbursed on an hourly basis. So if you recall, I said that replacement services are paid at $20 per day. Attendant care, conversely, is reimbursed at around $12 an hour, not per day, an hour. If it's provided by an unskilled person such as family member, but if it's provided by a company, which some of you will need a company to provide attendant care, it's reimbursed at a much higher rate. So just an example of why this is a valuable benefit. If your doctor prescribes you 8 hours a day of attendant care, that's around $2,800 per month in attendant care benefits, or $33,000 a year. And so it can really add up depending on the number of hours you are prescribed. And unlike with replacement services, there's no 3-year limitation to this benefit. As long as your doctor is writing prescriptions for the attendant care and you have the coverage in your policy, you can get attendant care. For example, I have a current client who's been getting attendant care since 1986. I have other ones from the 90s that are still getting attendant care. And so, it is something that you can continue if you actually need it, if a physician actually prescribes it. You can't just claim attendant care without the medical necessity that is justified by physician script. It should be noted that after the 2019 law changes, there is now a restriction that family members can only provide 8 hours a day of attendant care, and that's whether they provide directly or through a company. So if you have a script for 16 hours of attendant care, you can only have a family member do 8 hours. The rest is going to have to come from someone else, such as a company. As you can see, attendant care is a very significant benefit, but it's also one that's extremely difficult to get paid. Insurance companies hate paying attendant care. They will very rarely pay it voluntarily. It's a very expensive benefit, and they have found a lot of fraud in attendant care. Unfortunately, there's some plaintiffs who claim family members are taking care of them, and then they bill the insurance company, but then the insurance company later finds out that the family member was never actually providing the care. They have surveillance video of the family member or the plaintiff doing stuff where they're not in the presence of each other. The family member is on a cruise somewhere. The plaintiff is out playing basketball when they say that they need help with just about every task. They can't get in and out of their couch. They can't put on their clothes, and yet they're out playing basketball or shoveling snow. So insurance companies are inherently skeptical about attendant care, and it is a very difficult benefit to get paid. If you are going to pursue attendant care, you need to do it very diligently and carefully and through our guidance. There are certain other PIP benefits that you may be eligible for as well, such as medical mileage and home mods. If you believe that you qualify for any of those, please talk to us or the handling attorney and paralegals in our office, and we can get you more information. But that's all I want to discuss about the PIP cases. Now let's move on to your third-party cases. So, as I told you earlier, there are two types of cases that you may be entitled to when you get into an accident. I already discussed the no-fault case. The other type of case is the bodily injury claim, otherwise known as a third-party case. The third-party case is for what we call non-economic damages. This is your compensation for your pain and suffering. Someone else, the at-fault driver, caused your injuries, and therefore they owe you for the pain and suffering that they caused. Third-party cases is where most of your money comes from, like the money that you put in your pocket. Unlike with the first-party case, third-party cases, the money that you recover is yours, minus the attorney fee, of course. In the first-party case, unless you have a wage loss claim, the money technically is not supposed to be for you. And a lot of clients oftentimes don't understand at the end of the case what happened to the money or why they didn't get X amount of dollars when the settlement was a fairly significant. In no-fault cases, the money cannot be claimed for you. It is a claim for medical bills and for people who helped you, unless you have a wage loss claim. Third-party cases is where the money comes to you. Again, first-party cases are not designed to compensate you. Third-party cases are. In order to have a third-party case, we need to prove that the other driver was at fault for the accident and that you have sustained a serious impairment of a body function as a result of the accident. Now, serious impairment of a body function is a legal term that's in the statute that basically means that you have a very serious injury that is supported with medical records and medical imaging. And you have to be able to show that your life has been turned upside down as a result of the accidents. You have to be able to show that before the accident you were healthy, you lived a very productive, a very happy life, and then since the accident you can't do a lot of what you were able to do before the accident. Your deposition testimony is very important for proving these points. So you have the aspect where your medical records has to show you have serious injuries, and it's not from pre-existing injuries but from new injuries, or there has to be an aggravation of your prior injuries, and you have to show that your life has completely declined as a result of the accident. If you cannot show these things, your case will get dismissed by the judge. It is a very high standard to meet, and a lot of cases do get dismissed because the plaintiffs are unable to show that their life has changed. I've seen cases get dismissed because the plaintiff stated that the only thing they can't do since the accident was they can't play golf. They had a passion for golf and they talked about it a lot. He talked about it a lot at his deposition. That is not sufficient to show a threshold injury. That is not sufficient enough to show what the law requires. You need to be able to show that you can't golf anymore and that you need help with laundry, cooking, cleaning, that you can't travel long distances, that you have issues working at your job, that you can't do social activities, all of that. You need to show all of that in order to have a viable third-party case. So the last thing about third-party cases, before I get into the million-dollar question, which is how much is my case worth, I wanted to discuss uninsured motorist coverage. So what happens if you get hit by a driver that does not have insurance, or if you had an accident where it was a hit and run? If you are in this situation and you have your own insurance policy and you purchased something called uninsured motorist coverage, then you will still have a third-party case. It will just come from your own insurance company instead of the at-fault driver's insurance company. So in other words, if you were in an accident with someone who was uninsured, or they took off after the accident, your own insurance company will take care of the third-party benefits. Now, in order for you to qualify for uninsured motorist coverage, most policies require a few things. First, you have to call the police within 24 hours of your accident, and there must be contact between the uninsured vehicle and you. You can't say that someone swerved into your lane and forced you to turn the wheel and then you went into a median and that's how the accident happened. If there was no actual hit between the uninsured vehicle and your vehicle, you can't make a claim. Okay, so now the part that you've all been waiting for. How much is my case worth? This is the question that every new client wants to know, and every new client has in the back of their mind, whether or not they're asking it or not. How much am I going to get from this case? So before I get into that, I want to dispel some of the myths and the falsities that have been put out by the TV commercials, by the random guy that's on the corner who thinks they know everything about car accidents, all the rumors that are put out by your coworkers, your church friends, your cousin's boyfriend, sister's nephew, and whoever else is out there putting out unsubstantiated, unsupported myths that I hear all the time. And I want to say this is the cold hard truth, and you need to hear it now rather than later. The $1 million cases that you hear about, they comprise about 1% or less than 1% of all auto accident cases. And in fact, the majority of auto accident cases are not even worth six figures. Yes, I'm sorry to break the news to you, but that is the actual fact and data supported by the settlement records that have been compiled by all the jurisdictions. The majority of these auto accident cases are not worth six figures. But yet, all you see on TV is, I got in a car accident and I got $300,000. I got in a car accident and I got $750,000. Well, why is that? Well, quite frankly, it's because the TV lawyers are not going to go on TV and advertise all these $20,000 and $30,000 cases they have. It's not competitive. It actually is not going to get the prospective new clients to call. The TV lawyers are going to put out their best cases and try to attract as many new clients as they can based off of their best case scenarios. After all, why would you want to go to an attorney that's talking about $20,000 over an attorney that's talking about $300,000? And so, unfortunately, what the TV ads do not tell you is that the $300,000 cases make up only a small fraction of the cases that they bring in. And this is why most TV lawyers refer out almost all of the new clients and only keep a handful. I'm good friends with several of the TV lawyers. Many of you may be with our firm because of a referral from a TV lawyer. They know that the majority of the cases are not worth the big bucks, and that's why they're sending them out. And unfortunately, the TV ads are extremely misleading because they aren't giving you the full picture. The TV ads don't tell you that it is rare for anyone to have bodily injury coverage on their car that is more than $250,000. It is very rare. You hardly ever see anyone with more than $250,000 in coverage. And most of the times it's less. Before the law changed in 2019 and 2020, most people didn't have that much coverage. The former minimum coverage for bodily injury cases was $20,000. So a lot of these cases were settling for $20,000 or less because that was the maximum coverage for these bodily injury cases. So when you see these settlements and verdicts that are at $500,000 or $600,000, it's because the plaintiffs were usually hit by a commercial truck. That's not what is being told, but that is what happened. Most of these cases that are in the $500,000, $600,000 or above range, really anything above $250,000, is usually the result of an accident with a commercial vehicle, with a truck. Unfortunately, the TV ads never mention this. The TV ads also never mention that for those clients or plaintiffs who do have large value cases, most of them have either lost a limb, they are quadriplegic, they're paraplegic, or they've had multiple surgeries as a result of the accident. If you have not lost a limb or had a very serious brain injury that requires around-the-clock nursing, or if you have not had multiple surgeries, your third-party case is not worth the big bucks. That's just the cold hard truth, unfortunately. The TV ads won't tell you that. They only tell you what these clients received without any details or explanation. And I'm telling you this because it is important for you to have an understanding of your case, the potential value, and what is needed for you to ensure that you're in the best position for success. Ultimately, our goal here at the Seva Law Firm is to make sure you get the most money you can get based on the circumstances you have. And we don't want you chasing a number that is unattainable and screwing up what is a very reasonable and attainable amount. In actuality, most third-party cases are not worth more than six figures unless you get a surgery. I'll repeat that. If you did not get a surgery, do not expect a settlement for over $100,000. It's possible. It's definitely possible, and I don't want to discourage any of you. It is possible to get a six-figure settlement without a surgery, but it is also against the grain and against the numbers that have been historically been produced for decades. Again, these are not my numbers. I wish that wasn't the case, but this is what years and years of data from settlements reflect. But going back to the initial question posed, how much is my case worth and how much will I be getting? First, recall that many of you will have two cases as part of your auto accident lawsuit, the no-fault case and the bodily injury case. Now, the no-fault case oftentimes will have a lot of value to it because there'll be a lot of unpaid medical bills and attendant care after your accident. It is not uncommon for these cases to be worth more than six figures. So a lot of these PIP cases are in fact six-figure cases or $250,000 cases. A lot of the PIP cases are. But remember, a lot of that money is not allocated for you personally. Most of that is allocated to your medical expenses. So how much you personally can get from these cases will depend primarily on what you what you can claim, and how strong your case is. So for instance, if the only thing you can claim in your no-fault case is medical bills, technically you won't be able to get anything from the case. However, if you're claiming medical bills and agree to waive your future benefits, that means you agree to not bill the insurer for the accident anymore, then you'll likely be able to get something in the range of $5,000 to $20,000 off of your no-fault case. Could be less, could be more, but that's a reasonable range for non-catastrophic injuries. If you're claiming only replacement services, then you'll be able to get something between $5,000 and $10,000 in your pocket. That is a reasonable range for most non-catastrophic injuries for replacement services. If you're claiming both medical bills and replacement services, and you're looking at a release of features, you could aggregate those two, and then you're looking at something between $10,000 to $30,000 in your pocket. Again, it could be more or it could be less depending on the circumstances. Now, if you're adding wage loss into the mix or attendant care, that's when your first party case can get really high. And there are circumstances, there absolutely are circumstances where you can put six figures in your pocket, especially if you have all of the claims for PIP, medical bills, attendant care, replacement services, and wage loss. But again, it all depends on the facts and circumstances of your case. If you had a high-paying job, you will get more money through your PIP case. If you had a low-paying job, then not as much. If your doctors only disabled you for a short period of time or return to work very quickly, then your wage loss may not be worth as much. Same applies for attendant care. The more hours you can claim, the more your case will be worth. And in fact, attendant care often plays the biggest part of your of the amount you can recover from PIP cases. Also, remember that no-fault cases are for economic damages. And that means if the insurance company owes you $25,000 for wage loss and they pay you $10,000 before you hire an attorney and file a lawsuit, you cannot then claim the full $25,000 in the lawsuit. You can only claim the $15,000 that was not paid. So, as you can see, there are many factors that go into the valuation of a PIP case. Ultimately, how much you get out of your no-fault case is nearly impossible to predict. Our job as your attorneys is to blackboard the highest possible amount and present the evidence that supports the insurance company paying something close to that amount. When it comes time to settle, it is our job to ensure that the medical bills and liens are taken care of and then let you know how much will be left for your pocket. And we do that by getting a settlement offer, taking out the attorney fees and costs, seeing what's left, allocating the appropriate amount to the doctors, medical bills, and lien holders. And the medical providers that we typically deal with are usually accepting 40 to 60% of your medical bills. And after all of that is paid off, whatever's left is for you to keep. So again, the attorney fee and costs come off the top, then we pay the medical bills, the lien holders, etc. After that, whatever's left is yours to keep. And sometimes that can be a lot of money and sometimes it might not be. And it all depends on the circumstances of your case. Now, third-party cases are a different story. They're much more straightforward. There are no bills to pay out of your third-party case. So whatever the offer is, take 1/3 out and that's approximately what you'll be getting. But how much will that settlement be for in total, you're probably wondering? Well, with the PIP case, I told you that you can get in the ballpark range by understanding and adding up the total replacement services, wage loss, attendant care, and medical bills you can claim. But for the third-party case, the total settlement value is based entirely on the severity of your injuries and the type of treatment you get, as well as the policy limits. For instance, if you're fairly healthy before the accident and injured your neck and back in the accident, if your MRIs show disc herniations, your doctors disable you from work, you treat with physical therapy, and then get some pain management, including injections as treatment, then the value of your case can be estimated at anywhere between $20,000 to $80,000 based on that scenario. I know that's a pretty wide range, but there are so many factors that play a part in determining the value. That's why we need to give a pretty extensive range. For example, the photos of the vehicle can play a very big part in determining the value and can send it from 20,000 all the way to 80,000 if the photos are very bad. Conversely, if you have very bad injuries, but the photo of the accident only shows a minor scratch on your bumper, your value is going down. If you have pre-existing injuries, but everything else checks out, your value of your case is still going to go down. If you're healthy before the accident, then your value of your case is going to go up. If you've been in multiple accidents, then you're looking at a lower end of the range for your recovery. Multiple accidents work highly against settlement values. On the flip side, if you've had a surgery or a long-term hospitalization, then your range jumps from 60,000. Cut that. If you've had a surgery, cut that. On the flip side, if you've had a surgery or a long-term hospitalization, then that range can jump all the way to 60,000 to 200,000 potentially, or 250,000. And of course, if you lose a limb or sustain a serious brain injury, and I mean a severe brain injury where you're in a childlike state, then you're looking for the potential of well over $250,000 in that situation. However, regardless of what your injuries or treatment is, you're going to be limited by the policy limits. If the policy available to you is only $50,000, even if you have multiple surgeries or a lengthy hospitalization, your case will still be limited by that $50,000. Ultimately, policy limits control in these third-party cases. With that said, I want to go through a list of factors that can add value or diminish value in a case. Let's start with what adds value to cases. So first, if you have a good insurance company or good adjuster, that makes a big difference. If your injuries are severe and detected by objective medical tests, so if you have positive MRIs, that's going to help a lot. If you had good health before the accident, if you don't have a lot of prior injuries or pre-existing conditions, that really helps with the value of your case. Getting quality medical treatment helps a lot. And quality medical treatment means going to doctors who are not on the radar of the insurance companies, getting pain management treatment rather than just physical therapy and chiropractic, because physical therapy and chiropractic are considered conservative treatment. Obviously, surgical consults are huge, and then surgeries are even better. If you get a surgery, that's about as quality of treatment as you can get. Also, as mentioned before, strong photos of the accident scene and your post-accident injuries will be very helpful. If you have scarring, bleeding, take pictures right away and submit that to us. If there's clear liability for the at-fault driver, that helps a lot. The inability to work plays heavily on the analysis as well. The inability to do your ADLs, your activity of daily living. If you can testify that you are unable to cook, clean, do laundry, drive, etc., that also helps. Inability to do hobbies also increases the value of your claim. And then having a good judge also is very important in these situations. And this list is ranked from most important to least important. So the most important factor in determining the value of a case is always going to be who the insurance adjuster is and how they are looking at this case. Because some adjusters will look at what I consider a good case and still not offer any money because that's just how they are and that's their personality and that's how they operate. Whereas some adjusters will take a bad case, and because they are a sympathetic adjuster or a caring adjuster, will just offer up a lot of money without digging too much or without caring that you had a significant amount of pre-existing injuries or without caring that the accident was very minor. So that right there is always going to be the number one for me. Next, I want to discuss the factors that would diminish the value of your case. As expected, having a bad insurance company or a bad adjuster is going to be the biggest factor in taking the value of your case down. But more importantly than the insurance company is the actual adjuster. If you get an adjuster that is extremely aggressive, always believes that there's fraud in a case, or simply just does not like you for whatever reason, they're unsympathetic, the value of your case is going to drop significantly. It's going to be a real dogfight to try to get anything. Next, if there's any coverage issues in your case, that's going to diminish the value of your case. And when I say coverage issues, I mean if you have a potential coordinated policy, or there's another insurer that's higher in priority, the insurance company that we believe is responsible may not pay anything at all, because if they are not the highest in priority, then they have an absolute zero responsibility, and therefore may not have to pay anything. So coverage issues are a big problem. Next, if there's liability issues, especially on third-party cases, the value of your claims will diminish. If the police report indicates that you were potentially at fault, or does not indicate that the other driver was at fault, it will be extremely difficult to overcome and try to convince the insurance company to put up a reasonable offer. Even if the police officer did not interview you, and that's the reason why the other driver was not assessed any fault, or if that's why you got a citation, the police officer didn't talk to you at all, it doesn't matter. Once the police report shows that you were at fault or the other person was not at fault, we have liability issues, and that will diminish the value of your case. Fraud obviously is another big issue that diminishes the value of cases. For instance, if you were caught on surveillance doing something you shouldn't be doing, if you testify you can't lift a milk jug, but then you're on surveillance pushing a heavy snowblower, if you testify that you can barely walk upstairs, and then they catch you on video playing basketball, that's fraud. If you fill out your insurance application using an address that you don't live at because it's cheaper at another address, that's fraud. If you fail to list additional people in your house on your insurance application, that's fraud. If you fail to identify prior injuries or prior conditions in your deposition and your discovery answers in your application for benefits, that's also fraud. Any of these issues will significantly diminish the value of your case and lower how much you can get. Prior accidents is another factor that will diminish the value of the case. The more prior accidents you have, the lower the value of your case will be, unfortunately. Each accident you get in is going to make it harder for you to get paid. Same thing with pre-existing health conditions. Anytime there is a prior condition or injury that the insurance company can point to, they're going to try to do that. So if you had a back injury that started in 2002 and you were fine, but now you got an accident and now your back is hurting again, the insurance company is going to try to pin everything on that 2002 back injury and say that's the reason why you have pain, is because you never resolved that prior condition. So anytime you have any prior conditions or any prior injuries, it's a ready-made defense for the insurance company, and they're definitely going to use those defenses. Next, the lack of treatment will diminish the value of your case, because treatment is really what the insurance company uses to determine whether or not this is a serious case or a serious injury. They look at not just the amount of treatment, but the quality of treatment. So if you've been to pain management and a surgeon, a neuropsychologist, and neurologist, that's good. If you've only been to a physical therapist or a chiropractor, that's not good. That lowers the value of your case. If you've only treated for 3 months, that's not good. If you've treated for the entirety of the case, that's good. Surveillance and social media are also big issues that affect the value of your case. Obviously, if you're caught on surveillance doing things you shouldn't be doing, that's going to knock down the value of your case. But also, if you're on social media posting that you were on a vacation, that you were out dancing, pictures of you looking like you're completely healthy, even though you may be in pain at the time, if you look like you're having fun, that's going to cut against the value of your case. That's going to hurt your case, and that's going to diminish value. Failure to cooperate is also a factor that diminishes the value of your case. And when I say failure to cooperate, I mean failing to adhere to the rules that are set by the No Fault Act and by your insurance policy. So, for instance, all insurance policies and the No Fault Act require you to attend independent medical examinations with doctors selected by the insurance company. And if you fail to attend these IMEs, that's considered a failure to cooperate, and that will diminish the value of your case. If you do not sign authorizations for your medical records, that will be considered a failure to cooperate and will diminish the value of your case. If you fail to follow through with treatment, that will be considered a failure to cooperate and can diminish the value of your case. And so it's not just important to cooperate with the insurance company, but also with the legal process and with your lawyers, because there are aspects to the case that we need you for, and if you don't participate, there's not a lot we can do. Next, going back to work quickly is also unfortunately a factor in diminishing the value of your case. I would never suggest that a client stay off work if they can work, and I will discuss a little bit more about this later. But if you do go back to work quickly, it is a factor that is used against you. The insurance company will say, how are you already back at work if you're so injured and you claim that you can't do X, Y, and Z? How are you back at work? So going back to work quickly is going to affect the overall value of your case. Next, of course, admitting that you can perform your ADLs, your activity of daily living, is something that can hurt your case. Obviously, you have to testify and you have to provide information that is accurate and true at all times during the litigation process and even before litigation. And so if you do admit that you can cook, clean, do laundry, whatever household chores without any issue, then your case is going to significantly lose value. Next, I want to discuss some of the pitfalls to avoid. During the pendency of your case, you always have to keep in mind that the insurance companies are going to do whatever they can to ensure that you do not get paid. They are for-profit companies, and their business model is to collect as much in premiums as possible and pay out as little as possible. The more they collect and the less they pay out, the more they can make. Ultimately, the insurance company's loyalty is to their shareholders and not to the insureds. In other words, they don't care about you, they care about their shareholders. So with this in mind, you need to be cognizant about the pitfalls that exist when pursuing auto accident claims. Number one, lawsuits are speculative. At all times during the pendency of your lawsuit, you need to try to live your normal life. Do not count on the money or expect any money to come from your lawsuits. There is no guarantee of how much money you will collect, if at all. So although going back to work after the accident will likely hurt your case a bit, I would never recommend anyone staying off work if they can go back. Go earn your money and ensure you don't lose your employment. That is number one, most important. We will explain to the insurance company and to the facilitators and to the jury, we will explain that despite the fact that you're working again, you are doing so with significant difficulties and while in pain, and we will explain away the situation, but you should not stay off work just for the purposes of the lawsuit. Also, try to avoid taking out loans. There are loans that are available from lawsuit financial companies, and I know sometimes it's unavoidable. You have bills to pay, you need the money, and this may be your only avenue. But the interest and the escalation of the costs on these loans are extremely high, they're exorbitant, and they will often eat up your entire settlement check. So I highly advise that if you do not need to take out a loan, do not take out a loan. Second, settlements are always better than trial. 95% of civil cases settle before trial for a reason, and that is because trial is such a crapshoot. No matter how great your case may be, there's always a chance that you can lose. And that is why I say it is always in your best interest to accept reasonable settlement offers. I've seen way too many people scoff at guaranteed money from a settlement offer, then go to trial and end up with nothing. So when there is a reasonable offer presented to you, consult with your attorney, get an opinion, and then if it is in fact deemed reasonable by your attorney, please accept it. Third, do not compare your case with others. I repeat, do not compare your case with others. Every case is different. Just because someone was in the same accident as you and got $50,000 doesn't mean that you're going to get that much. Just because someone had the same injuries as you and got $50,000 doesn't mean that you're going to get that much. There's just no correlation or comparison when it comes to different lawsuits and different people. The most important of which is who is your insurance company and who your adjuster is. Two adjusters can look at the same exact set of facts and place completely different values on them. Completely different. And so what you want to do in these cases is put yourself in the best position to get the best resolution and not worry about what others do or what others get, because your case is going to be different than everyone else's. Next, I want to give you a few tips on how to put yourself in the best position for success in your lawsuit. First and foremost, you need to understand the law. And to do that, I suggest 1, watch this video a few times. Watch all the videos that we have sent to you and suggested you watch. Review the information on our website. We have a ton of information on our auto accident portal on our firm's website that explains every aspect of auto accident claims and about the litigation process. The more you understand about how this all works, the better success you will have in the case. Second, continue to treat. One of the biggest factors in PIP and BI cases is the amount and quality of treatment you obtain. Pain management, surgical consults, neuropsychology, neurology will increase the value of your case. Not to say that PT and chiropractic treatment is not quality treatment. You still need to do that. It's just you can't rely only on PT and chiropractic. What we don't want you to do is have large gaps in your treatment, or we don't want you to stop treating, especially if you need that treatment to get better. Third, do not get advice about your case from anyone but your lawyer. I repeat, do not get advice about your case from anyone except your lawyer. Oftentimes, your friends, family, even your care providers and your medical providers think that they have some special insight into accident claims and that they have some advice that's going to help you get to the next level. They may think that your lawyer is not doing enough for you, or your lawyer is not doing what is needed. And these people may be well-intentioned and provide you with what they think is the best advice, but I'm urging you and I'm begging you to please do not listen to these people. Do not take advice from anyone but your attorneys. These other people who are giving you advice never know the full picture or the circumstances surrounding the case. They do not have access to the claims file. They do not have access to the defendant's discovery. They do not have access to records from all the medical providers. They do not have access to the defense strategy. They may not even know all of the laws and the applicable statutes that we're working with. It is impossible for them to know the full circumstances of your case, and so their advice will be based oftentimes on misinformation, and they will end up hurting you. So please only listen to your lawyers when getting advice. Finally, I want to end by touching on another frequently asked question, and that is, how long is my lawsuit going to take? And the answer to that question is the same as the answer to a lot of the questions regarding your lawsuit, and that is, it depends. It's a case-by-case scenario. Every case is different, and many factors play a part in how long the case takes. But with that said, I would say in general, it takes about 1 year to settle a lawsuit. That is, from the date of the filing of the lawsuit to the completion, it will take approximately a year. And it could be more, it could be less, but that's just an estimation. We have an excellent video on our website, as well as a great timeline graphic that goes through the process and takes you through each step of the litigation process. I highly recommend you watch that video to get a better understanding of the process. And just to clarify, the 1 year period I just discussed was 1 year from the date of the filing of the lawsuit, not a year from the date of the accident, or not a year from the date you signed with our firm. In fact, we typically do not file a lawsuit as soon as you sign with our firm, and that is because we will usually try to attempt pre-suit resolutions or obtaining pre-suit benefits. And the reason we want to do this before filing suit is so that you can get paid quicker and with less investigation and hassle from the insurance company. If and when it is clear the insurance company is not going to pay, we will then file a lawsuit. And on average, that is around 3 months after you sign with our firm. It could be more, it could be less. But looking at this all together, I would say from the date of the accident, because a lot of you want to know, want to say it's been a year since the accident happened and why hasn't my case settled? But it's not from the date of the accident, but from the date of the accident, if you wanted to estimate, it's usually around a year and a half before your case settles, depending on when you sign with us. And there's a lot of factors that come into play, but it's usually a year and a half. Could be more, could be less, but typically you're going to be dealing with this for about a year and a half. Ladies and gentlemen, Seva Law Firm clients, that is all I have for now. I hope that you found this video informative and helpful. Most of what I discussed was very generalized. As I keep saying, every case is different, so if you have any specific questions or concerns, please reach out to us and we can answer your questions. Thank you so much for your time, and on behalf of the entire firm, we look forward to working with you.